Thank you very much. Sorry, I'm confusing myself. You handed up a copy of Seymour.
I did. I can hand up another one.
It's always because I've got
Lord Justice Peter Jackson's given me his. I left it behind, but I don't need it now. Yes, right.
So, my lord, very grateful for the extra time and for the opportunity to finish this off, which I should be able to do very quickly. So far as Seymour and Taché is concerned,
Yes.
I respectfully adopt paragraph 48 of my learned friend's skeleton below, which is supplemental tab 5, page 67. And for the reasons that he gives there, we say that these are pending proceedings, and the pending proceedings includes the counterclaim, even if the counterclaim is brought after IP completion day. And we do say that is not only consistent with the reasoning in Seymour and Taché, but the reasoning of His Honour Judge Corson in that case expressly addresses the scope of the relevant provision of the withdrawal agreement. If we can go there briefly, this was an application to stay English proceedings under the Brussels I regulation in favour of what were said to be related proceedings in Belgium, where it was said that they only became related proceedings as a result of developments that had taken place after IP completion day. And the judge deals with that submission at paragraph 66. I'm afraid it doesn't have page numbers. And he sets out the submission that's made on behalf of Dr. Seymour. That this is the last end of paragraph 66, that it's necessary that the two sets of proceedings should have been related at the end of the transition period. And he explains why that matters. And then paragraph 68, he says that the submission is made that it cannot be right that a party can improve their position by changing their case after IP completion day. And paragraph 69, he sets out his conclusion that that's wrong. And he explains at paragraph 70 why that's wrong. And I'm already eating into my own friend's time, so I won't go through that at length. But it's the whole of 70 leading to the last line in particular. Article 67 and the additional wording "and in respect of proceedings or actions which are related to" only makes sense if construed as encompassing a relationship that only arose after the end of the transitional period. And then at 71, he quotes the European Commission notice to stakeholders on Article 67 of the withdrawal agreement, which says in terms, fourth line down, this addresses situations, third line, even if such related proceedings or actions are instituted after the end of the transition period. And then at 74 to 75, he accepts the submissions of the parties that were seeking the stay. The proper construction is that it does apply to new additions post-Brexit. And in fact, the proceedings get dismissed for other reasons, but he says that if they hadn't been dismissed for other reasons, he'd have stayed it under the Brussels regulation in favour of Belgium. And the timing here, if we can have a very quick look, please, at the chronology in the core bundle, tab 7, page 68. It's not the core bundle. So chronology here, if you look at the middle of the page, on the 27th of March 2018, on the 8th of March, there's a letter of claim from the claimants. On the 27th of March, my clients commenced proceedings in the UK IPA. 24th of July, the English claim is issued and served. And as a result of Article 91 of the Community Designs Regulation, the English court, because there were pending proceedings at the time of issue,
we're aware of all this.
they had to stay at and so where this goes is, I posited a case in argument this morning where one filed a counterclaim at the earliest opportunity, but that was post IP completion
Yes.
day. That's this case. We filed the counterclaim at the earliest opportunity. So if there's no power to hear a post-Brexit counterclaim, then the claimant, by timing themselves right, could get a free shot at not having their infringement proceedings opposed. And that would apply whether or not we'd ever been to the EU IPO.
On this, because as I understand Simon and Taché, it's all based on an interpretation of Article 67 of the withdrawal agreement.
Yes.
So this presupposes that Article 67 is applicable, but your argument is it isn't applicable.
No, my article it is applicable for all of the other stuff. It just doesn't apply to that one sub-paragraph of Article 86.
So you rely upon Article 67 as providing the jurisdictional basis for your counterclaim.
I do. Well, if contrary to my primary submission, the UK legislation doesn't do the job. We had a debate about the
I
meaning
don't
of
understand how the UK legislation on its own provides you with jurisdiction for your counterclaim.
Well, I, to the extent that I need to, I do rely on Article 67, yes. Just as we say it's analogous to Simon and Taché, it's analogous to Sky Kick. The court in those cases had the powers in pending proceedings. So does this court. We say there's a special carve-out for the particular exception, the particular procedural bar that we're arguing about, but otherwise it's the same as those cases. Last point, then I will sit down. It was suggested by my learned friend that it wasn't open to me to argue that res judicata doesn't apply to the UK clone right. The position that the parties took below is summarised in the judgment by the learned judge, Core Tab 9, page 89, paragraph 69.
Yes.
So the learned judge's understanding is that the primary position of both parties was that it should be the same, but last sentence of 69, each of them argued for the opposite conclusion and both as a fallback.
Yeah.
So we'll see on what basis it's suggested it was conceded below, but it doesn't look like it. And then my main skeleton, and I showed your lordships this earlier, 53 to 56, makes the point about the UK registered design being a different right. And it was suggested that paragraph 18 of my supplemental skeleton somehow withdraws that or concedes that, and I don't accept that that's the effect of the paragraph. It doesn't say that. So for what it's worth, the argument is open to me, and it was suggested by my Lord Justice Arnold that it's different from the international patent case because here it's the same law. Well, it's the same country's law, but it's not the same law, it's not the same rule. And so we do say that that is a relevant distinction. And my learned friend in my submission does need to explain why this is different from the international patent situation. My lords, unless I can be of any further assistance, to the extent I've been of any assistance so far, those are my submissions.
You have been of real assistance so far, Mr. Vinyl, and tripped well with a fair amount of judicial intervention from the three of us. Yep.
Thank you, Lord.
My lords, as I say, I heard very loudly the requirement to cut to the chase. I shall endeavour to do so. Indeed, in the nature of the extensive written submissions, This is probably a subject where discursive advocacy is more likely to assist the court than simply me reading out a version of my skeleton argument. I want to go straight to the meaning of Article 86.5.
Yes.
But in doing so, I don't wish it to be thought that I'm not anticipating addressing my Lord Justice Arnold's question to my learned friend, Mr Vinell. Indeed, Mr Vinell said that he didn't want to take up too much of my time. I was delighted for him to do so because he was very much following the argument that I put at paragraphs 48 and 49 below. My lords will not know, but my Lord Justice Arnold knows that I've made no bones about the fact that my entire career is based on waiting for Lord Justice Arnold to put the point much better than I could and then saying I agree.
Ooh.
And therefore I find myself in the unfortunate position on this occasion of agreeing with my opponent and disagreeing with my Lord Justice Arnold. So I will do my best to explain why I'm having what it can only be described as a personal nightmare moment in terms of submissions. But to foreshadow where I'm going to go, I'm going to say on that point that the wording of the English legislation to which my Lord Justice Arnold has pointed does not compel the conclusion that he suggests comes out of it. To the contrary, the wording actually allows for precisely what we say operates, namely that the court in pending proceedings continues as a community design right court and in that context has the power and jurisdiction to deal with counterclaims for invalidity, and that will also prove to be consistent with the overall scheme of the Brexit legislation and indeed consistent with the pronouncements of other judges. I think the only difference between myself and my learned friend is that I don't suggest that the Simone case compels that conclusion. I simply say it's supportive, consistent with what I said at paragraph 48 at first instance. So, my lords, there were only three other matters of very brief framing for the discussion of Article 86.5. The first is that you will gather as I go on that the thrust of our submissions is that there are three classes of case in the contemplation of the legislation. Those where all matters of proceedings are completed before IP completion day, that's fine, that's dealt with under the EU law if the EU law applies. And those that are started and finished after IP completion date, that's also fine. Those are dealt with under the UK law, subject to any retained EU law. But there is a third category of cases, one that is being given special consideration. Those are pending proceedings started before IP completion day and ongoing at IP completion day. And special consideration has been given to them, and of course the detail will matter, but the general picture is that they should exist in a kind of bubble, carrying on even after IP completion day as if they were operating under the law that existed before that, and that the entire scheme of the Brexit legislation has that contemplation in mind. In that context, the scope of the Brexit legislation has been the subject of our written submissions and of a number of lengthy judgments. And it is sufficient to say that everything I intend to submit to your lordships is effectively a paraphrase of what Lord Kitchen says in paragraph 451 of the judgment in Skykick, which we will look at. And I understand and submit to you is mutatis mutandis, consistent with what the judge has held in this case, save in one respect. In the very final subparagraph of 451 of Skykick, Lord Kitchen is clear that the status of the RRD, or in that case the equivalent cloned trademark, is to be dealt with entirely as a matter of UK law, whereas the judge in this case has taken the view that in the context of pending proceedings, the RRD is dealt with still under the old law, and I want to explain why that's the conclusion he's come to, we say is a supportable conclusion, but ultimately it doesn't matter a great deal to my client.
So is supportable or insupportable?
Supportable.
Yes, I see.
It's an understandable conclusion. It doesn't matter, however, to my client, my lord, because
Well,
let's say
I'm
he's
sure
wrong
it's
about-
understandable. You've got to say, if it's important, you should tell us whether you think it's right or wrong,
Yeah.
but you're saying it's not important.
Well, I say it is right, but if I'm wrong about that and the judge is wrong about that, it's unimportant to the ultimate question, which is whether or not the appeal succeeds, because this was a strikeout, and the strikeout is justified on the other basis, which the judge below found to apply in those circumstances, namely that the UK law of res judicata would also bar it. Now that leads me into the third framing observation, which is about abuse. Could I ask my lords, please, to take up the supplemental bundle very briefly?
Yep.
And turn within it to tab 6, which is the first instance argument written submissions of Zaun. And within that, to turn to page 94 and paragraph 11. We submit that this was an entirely fair and proper approach for Zaun to have taken. Their position was that if they were right on what are now effectively grounds 1 and 2, the consequence was to open matters up, even for the RRD. But if they were wrong about it, then subject to one other point which is not an issue before you, namely whether or not the EU IPO was capable of producing a final decision, they accepted that what they were trying to do would be an abuse. And indeed, that is how we understood my learned friend's submission to be made in his supplemental skeleton in the final paragraph thereof, and you can find that at tab 6 in the core bundle, at page 67 and paragraph 18. To be clear, sorry, I'll wait for my lord to find it.
Yep.
To be clear, we understand his submission that the legislative, or I should say the person making the secondary legislation, intended to allow something that would otherwise be an abuse to be done. And if he's right about that, then the cascade then follows. And that is what he is, we understand, saying in 18, consistent with what was said below at 11. But orally today, before short adjournment, my learned friend seemed to say that in relation to the RRD only, even if he was wrong about grounds 1 and 2, he could still say that it wasn't an abuse. And we say that point is not open to him. It has been conceded. And the reason I spend a little bit of time on it, my lords, is because we do say it is the leitmotif that can be heard in the background of all of his submissions. It is his case that for some reason, without any express discussion of it at all, the drafter of this legislation has sought to allow something which would be otherwise an abuse of the court's process to go ahead. That's a very strong position to adopt, and we say unsurprisingly, it cannot be supported. And that takes me to 86.5.
Okay.
We say my learned friend's appeal falls at the first hurdle, because if Article 86.5 of the design regulation is indeed a provision that regards jurisdiction, then as a consequence of the terms of Article 67 of the withdrawal agreement, it shall apply to pending proceedings such as these, and it would do so on the construction found by the judge, but it would not do so on the appellant's construction. Now, with due care for the dangers of adjectival advocacy, we say Article 86.5 plainly is a provision regarding jurisdiction. I think my lord's looking for something, and I worry that I should pause for a moment.
I'm not.
Jurisdiction, we say, is a term that might broadly be said to refer to the right and power of a court to adjudicate on matters before it and to enforce its rulings. I had a look at a dictionary of English law, Jowett's 6th edition of the 15th of December 2023, which defines jurisdiction as legal authority or extent of power. Jurisdiction is thus, for example, the power of a court or judge to entertain an action, petition, or other proceeding.
Would you send us an electronic copy of that after the video?
Quite so, my lord.
Thank you.
It encompasses, we say, both the territorial scope of that court's power, the sense in which, for example, jurisdiction arises under the Civil Procedure Rules, paragraph 2.3, which talks of jurisdiction meaning, unless the context requires otherwise, England and Wales or any part of the territorial waters of the United Kingdom. And my lords will find that on page 36 of the 2025 edition of the White Book. But the term also covers the power of the court, or can do so, and that is the case when one talks about something like the Norwich pharmacal jurisdiction of the court. And in that context, one is also talking about the conditions under which such orders can be made. Indeed, section 151 of the Senior Courts Act 1981, which addresses the interpretation not only of that act, but also provides rules of construction of other acts and documents, recognises that dual aspect because it provides that jurisdiction includes powers. And my lords will find that at volume 2 of the 2025 White Book at page 2596.
Sorry, what section of what act was it?
So 151
Of
of the Senior Courts Act 1981. Article 67 of the Withdrawal Agreement, in referring to the continuing effect of the provisions regarding jurisdiction, it is not using that term in the confined sense of territorial questions, but also in the context of the court's competence to consider issues and its power to enforce its decisions. And that is because the purpose of Article 67 is to preserve the competence of the UK courts when sitting as community courts in respect of EU-wide intellectual property rights for pending proceedings. And that purpose is reflected, we say, in the decisions to date, which have arisen in the trademark context and which were concerned with the jurisdiction of the courts to grant relief on a Europe-wide basis. Now, I'll turn to those in a moment, or rather specifically to Skykick, but can we go straight to the wording of Article 86.5 of the Design Regulation, which can be found at page 484 of the Authorities Bundle.
Could I just ask while we're looking for that? I see there's recording equipment. Is somebody producing a transcript of this hearing, or is this here for something else?
There is indeed a transcript, my lord.
Yes, I should have mentioned that to my lords. I had a request to authorise it yesterday. I must admit, I was being old-fashioned. I was expecting to see a shorthand writer here doing it,
They usually do it remotely these days.
yes,
Yes, I think since COVID.
Anyway, it's been permitted by me.
Yes, and I apologise. Normally, the practice of the Court of Appeal is not to take breaks for the transcript writer, so I've not assumed you were going to do that. But
That's certainly my rather hard-hearted practice. Yeah.
I was asking not in a querulous spirit. I was just asking on the assumption that they're going to be made available afterwards.
Absolutely.
So that is the basis upon which my note-taking has proceeded.
Yes, and I'm afraid probably I've taken that assumption too in giving you references to the White Book.
That's helpful. Thank you.
Sorry, my lords, I was asking you to look at Article 86.5 and the wording of it. We say the words "no counterclaim for a declaration of invalidity of a registered community design may be made" is quintessentially concerned with jurisdiction. It removes from the Community Trademark Court the ability to consider issues of validity where the triggering conditions are met. There is no discretion provided for. If the triggering condition is met, then, as the article indicates, the counterclaim cannot be entertained. It cannot be entertained because another tribunal has already determined the matter. That is the triggering condition. We say it was a telling concession by my learned friend this morning when, as we understood it, he accepted that something which addresses which court can do something is a jurisdictional provision. We say that that's partly what you're seeing in 86.5. But we would describe it in the same terms that I think my Lord Justice Arnold was asking my learned friend about. We would say it concerns subject matter jurisdiction. If the triggering condition is met, then the Community Trademark Court has no subject matter jurisdiction in respect of the invalidity claim. There isn't, to be honest, a lot more to be said. it's no valid criticism of the judge that for that reason his judgment on this issue is brief. They're brief because it's plain from the wording. Now, in our submission, the place of Article 86.5 within the scheme of the title also points to it being understood as a provision regarding jurisdiction. That's the point we've made in our written submissions at paragraphs 36 and 37. But I can make it briefly by reference to Article 81, which you will find on page 483 in the authorities bundle. That is entitled Jurisdiction over Infringement and Validity, very fairly accepted by my friend to be a provision regarding jurisdiction. It gives the Community Design Courts exclusive jurisdiction over actions for a declaration of invalidity at sub D where they arise by way of counterclaim in an infringement action. Now, that jurisdiction is then twice qualified. First in Article 84, where the grounds on which that counterclaim may be based and the parties, essentially those who have got earlier rights, who may bring the certain allegations are set out. And second, we say, by Article 86.5, which prohibits such counterclaims where the triggering condition is met. If Article 81 is a provision that grants jurisdiction, then we say a provision that removes that jurisdiction can only be considered to be one that is, at the very least, regarding jurisdiction. My Lord, the argument made against us is set out in their written submissions at paragraph 39, where he says that you should understand 86.5 in different terms, either as a procedural bar or as a defence. We say that that's not a sustainable submission. It cannot be a defence because a defence presupposes the possibility of a determination that the design is invalid but for the defence, and Article 86.5 precludes consideration of the issue at all. Moreover, it has none of the hallmarks of an estoppel or an affirmative defence. Indeed, my learned friend's submission at 40.1 acknowledges that it doesn't. Article 86.5 is not operating as a rule of evidence or as a matter that must be pleaded. It is indeed a bar on the counterclaim for validity. To call it a procedural bar rather than a provision regarding jurisdiction to consider the validity claim is my submission to engage in a semantic debate without difference. Indeed, we say, ultimately, my learned friend struggled with the request that he define jurisdiction precisely because he didn't want to reveal that ultimately his position is one of semantics. The result is the same. The provision means that the Community Design Court that has been given jurisdiction over counterclaims for invalidity has no power to hear them if the triggering condition is met. Or may I phrase it another way? Regarding the jurisdiction given by Article 81D, Article 86.5 prohibits the exercise of that jurisdiction regarding jurisdiction. Now, in this context, my learned friend referenced a decision of the Court of Justice of the EU, BNP Paribas. He didn't really run with it in his oral submissions. I'm not going to take too long over it for that reason. We say it doesn't assist this court in any regard, and we make 3 points. The first is that BNP Paribas is concerned with the effect of recognition of judgments. It is not addressing whether something is regarding jurisdiction for the purpose of the withdrawal agreement. It was concerned with a specific issue as to the effect of the recognition of judgments under the judgments regulation. The key reasoning we submit is at paragraph 50 of that decision, if my lords wish to look at it afterwards. There it's distinguishing between procedural rules and judgments, but in doing so only to ask, what does it mean to recognise a judgment? So we say a different issue, no bearing on the current debate. Moreover, this is our second point. My learned friend deploys it on the premise that Article 86.5 is no different than Henderson and Henderson. But of course, the latter is different. It's different in its source of origin, it's a creature of English common law, and it's different in its triggering conditions. It requires, for example, that there be abuse, and it involves the exercise of the discretion of the court, unlike Article 86.5. And indeed, it's implicit in my learned friend's skeleton argument, where he compares Article 86.5 to a variety of matters, not just res judicata, but also limitation periods and locus standi, that he is acknowledging, as my Lord Justice Arnold put it, that Article 86.5 cannot simply be thought of as res judicata by another name. Accordingly, it doesn't help my learned friend's argument to point to a judgment in which a different thing is identified as procedural. His reference to BMP Baribar is, in our submission, the fallacy of petitio principi, because it assumes part of the conclusion in its premises, namely that there is a relevant analogy to be drawn. Third point, my lords. It doesn't help my friend. Even if it were right to identify 86.5 as procedural, that wouldn't answer the question of why, though being procedural, it is not also regarding jurisdiction. Again, we say it is both by reference to the direct effect of its wording and by reference to the role it plays in Title 9. My lords, I wasn't going to address the judge's second reason for holding that the article was one regarding jurisdiction, namely its place in Title 9. I know my learned friend spent some time on it this morning, but in my submission to you, I'm either right that it actually is a provision regarding jurisdiction, in which case that it's also so because of its position in Title 9 isn't going to take me any further, or if my lords are of the view it isn't one regarding jurisdiction, I'm not sure I can bootstrap it into being one simply by the fact that it's within Title 9. In any event, my lords, if you do wish to address the point, we've dealt with all of those issues comprehensively in my written submissions. I do, however, want to talk about Skykick, my lords.
Yes.
And that is supportive, we say, of the judge's conclusion. It's a judgment, obviously, in the context of trademark matters, but we do say it's highly persuasive because of the equivalence between the provisions in relation to trademark matters and the general governance of EU-wide intellectual property rights, which is the background Brexit legislation context. We also say that there is a notable consistency in the approach of judges on this issue, whether one considers the judgment of the Chancellor, in Beauty Perfectionists, His Honour Judge Haycon, in Craft, or Lord Kitchen and Lord Reed in Skykick. They've all come to the same conclusion as to what the extent of the provision in Article 67 of the withdrawal agreement is, and they all agree that it is the entirety of the relevant title. But I will concentrate on Skykick because it's the highest authority and it's also the most recent in time. My lords have seen it. I know my Lord Justice Arnold will know it very well. May I take it as read that I don't need to go back over the detail of the judgment, my learned friend having done so this morning, but can I instead ask you to take it up at paragraph 410 of the judgment of Lord Kitchen. And
Sorry, but I've
yeah, no, it's correct. It's page 208 of the bundle, my lord. Sorry.
And your lordship should now have head notes from both.
yes, thank you. I saw that's helpful, but we are actually now going to the text. Page 208 of the bundle, did you say? Yeah.
Yes, my lord.
And page, so that's para 400 and
Yes, and the paragraph I wanted to start with was 410.
Yep.
And there he is dealing with Article 67, and he references that in the context of the debate that he's having, because as he explains, that article is of particular importance, and this is at 411. It helps to answer the questions to which this aspect of the appeal gives rise, and he has to return to it. He then goes on to look at how that withdrawal agreement fits within the Withdrawal Acts 2018 and 2020. As he points out at the end of paragraph 419, there were for trademarks equivalent provisions for the amendment to the Trademarks Act as those that are now in contemplation by this court. And then at 423, he records a submission from Skykick by reference to the reasoning in Easy Group and Beauty Perfectionists, which the judge below in this case had reviewed. And may I draw your attention just to 2 points there. The first is at paragraph sub 1, for pending proceedings, the UK court continues to function as a community court. That's going to be important in addressing my Lord Justice Arnold's concern in a moment. And then the other one is at sub 3, where they are saying that no distinction can be drawn between infringement and validity. And that goes to my learned friend's submission that you can put this to one side because it was only really worried about whether or not you could grant an EU-wide injunction. The argument in that case was that it applied to both aspects. Now, Sky's contention, in contrast, was that there was to be bifurcation, the EU for the EU and the UK for the UK. And as Lord Kitchen indicates at 430, that was correct when a no-deal Brexit was contemplated, but it changed when the deal was reached. Another part of that context is set out at 434, namely that for those engaged in pending proceedings, there was a danger of arbitrary and unfair consequences if no deal had been reached and a guillotine came down. And for that reason, the withdrawal agreement sought to bring about an orderly withdrawal. Part of doing so was through the provisions of Article 67, which preserved the provisions regarding jurisdiction. Again, I'm going to say that motivation is relevant as part of the answer that is to be given to my Lord Justice Arnold in a moment. Then at paragraph 437 at the bottom of page 221, Lord Kitchen identifies the relevant provisions preserved and applied by Article 67 as all of those in Chapter 10. And my Lords will note there's absolutely no ambiguity here. It is all the provisions in that chapter, 122 to 135, which include the provisions that are equivalent to the ones found in the design regulation, to which my learned friend has pointed as examples of things that are not regarding jurisdiction. Now, 438 is also relevant because it explains the status of pending proceedings, namely that the UK court is still operating as an EU court for pending proceedings. As Lord Kitchen points out at 439, that is a construction that gives effect to the object and purpose of the withdrawal agreement. And as he also points out in that paragraph, the equivalent exceptions in respect of trademarks would, if inconsistent, fall to be disapplied. Now, my learned friend says in his skeleton all this is obiter. I think he refined that slightly in oral submissions to you. To be clear, our submission to you, my lords, is not that Skykick is binding on the issue before this court, plainly not. We say it's relevant by analogy, so whether a pronouncement is strictly obiter or not is in our submission not particularly pertinent. It is the reasoning that we recommend. In the context of the assessment of those reasons, we do say that while the question of whether the exceptions in the 2020 regulations are inconsistent with Article 67 or not is obiter, the underlying framework in which the entirety of Chapter 10 is treated as covered by Article 67 of the withdrawal agreement is not. It is a central part of Lord Kitchen's reasoning. That is also the answer to my learned friend's suggestion at paragraph 41 of his main skeleton, that all of these can be set aside because they're concerned with issues other than validity, because Lord Kitchen's reasoning encompasses issues of validity as well by encompassing the entirety of the title. Indeed, Lord Kitchen's reasoning, and this is, I suppose, the key point, is based on the purpose of Article 67, preserving the scope of the UK court to act as an EU tribunal for pending proceedings, a purpose, as he points out, and I won't quote them, but my lords will have read them, reflected in the guidance that he finds from the EU and UK IPOs. It's a conclusion, as he points out at 473, that provides a solution, avoiding arbitrary, wasteful and expensive consequences for the party. Now, that is a point that Lord Reid picks up on, and which we've addressed at 43 in our written submissions. His judgment begins at page 244, after an annex from Lord Kitchen that looks at some of the provisions that we've also been looking at, or the equivalents. There's a suggestion in my learned friend's skeleton at 9, and made this morning orally to you, that in fact Lord Reid was trying to be more pernickety, and he pointed to paragraph 488, where he picked out the phrase in Chapter 10, as if to say that Lord Reid is recognising that it might be just some of those in 488, We say that cannot be correct if you look at the sentence as a whole, because Lord Reid says they are set out in chapter 10, comprising articles 1, 2, 2 and following. He's clearly contemplating all of them, indeed the ones that have been expressly referenced by Lord Kitchen, and indeed also clear from later references, paragraph 495 that I asked my learned friend to take you to. But it is also worth noting what's said at 498 and 499, because here Lord Reid is addressing some of the equivalent paragraphs to those that have arisen for consideration thanks to my Lord Justice Arnold's question. In these paragraphs, Lord Reid is referring to the continuing jurisdiction to grant declarations of invalidity with EU-wide effect. We say it would be bizarre to suggest that this provision regarding jurisdiction was not qualified by a provision that curtailed that jurisdiction, or to treat the one that curtailed it as not regarding jurisdiction. Now, it is correct that Lord Reid, unlike Lord Kitchen, does not address the validity of the exceptions, but of course he did not need to do so. By the same token, nor does he suggest that they are in fact valid and to be applied. What my learned friend does not address is the point that we have made at 43 of our skeleton argument. Namely, the construction he contends for would have precisely the arbitrary results that Lord Reid suggests are to be avoided. The passage we've quoted in our skeleton is from paragraph 511, where Lord Reid talks of the need for legal certainty. And my lords will have noted that in the recitals to the withdrawal agreement, in particular the one that is found at the very top of page 599 in the bundle, and my lords may wish to briefly look at that.
Sorry, one bundle, give me a second. Yes.
At the very top of page 599 of the bundle, the very first recital at that page speaks of the agreement having as an aim separation provisions that prevent disruption and provide legal certainty, not only to citizens but also to judicial and administrative authorities. And the point made by Lord Reid is that to avoid arbitrary results, pending proceedings would be decided on the basis of the pre-existing law. Now that's achieved, we say, under the construction adopted by the judge, because for pending proceedings the design regulation applies, including Article 86.5. It's the appellant's construction that results in the parties being subject to precisely the vicissitudes of litigation that come from arbitrary questions of date. My lords, I had a...
All right, but if that's the correct approach, what's the rationale on this thinking for the exclusion of Article 86.5 from paragraph 9 of Schedule 1 to the 1949 Act?
Yes, we say my lord has equivocated there because the wording does not talk about an exclusion. Can we look at the wording of the relevant...
Well, finish off on what you were saying first, and then there's...
My lord, I had finished. The only thing I was going to say was I can illustrate how the vicissitudes of litigation might result in very arbitrary results, depending on the timing of the Board of Appeal's decision in the EU IPO, whether they do or do not decide to make a Court of Justice appeal or not, whether or not the infringement proceedings, let alone any counterclaim for invalidity, is only made after IP completion date or not. That cannot have been in the contemplation, we say, of an orderly withdrawal, because the aim of an orderly withdrawal was to treat there as being three groups, the two that are clearly either side, and then to address what happens for those pending proceedings by treating them as operating in a bubble that then continues onwards. It is the reason, though, we say, why once you've agreed, as I hope you will do with my submission, that 86.5 is clearly regarding jurisdiction, it then follows that ground one must, we say, fail with consequences that have a happy result, because the happy result is that everybody understood where they were and they're in the same position that they understood they were in from the outset. I wanted to turn, in that context, to ground 2, my lord, and it's in ground 2 that I wanted to look at the wording that is in issue here, which is that that was introduced into the Registered Designs Act in section 9.2, and it's there that I'm picking up on my lord's use of the word
I'm not saying don't do this. On the contrary, I think I'm very keen, like he is, that you should address this question. Logically, however, if you win on ground 1, your case is you're bound to win on ground 2. Am I overstating it? Perhaps I've confused myself as to what the grounds are.
No, I think my lord is right, because we say that the consequences, that the construction cannot be one, in which Article 86.5 is
Yes, and
excluded.
even, I think you go so far as to say, though you judge didn't put it this way, that ultimately, even if you can't, on any natural construction, get over the problem caused, but you simply do it by main force, a version of mar-leasing or something even stronger than mar-leasing, because the Withdrawal Act says that the withdrawal agreement trumps provisions to the contrary.
Precisely so. In fact,
This is secondary legislation.
the relevant authority is set out in the judgment
Yes.
and explains
Yes.
the status of that legislation. Lord Kitchen says the same thing.
Yes.
But what I'm about to address you on is why I think happily we can avoid
You're
that
not
scenario.
even in that situation. No. Okay, that's
My
fine.
lord, all the way along, there's been this underlying question. Is this just an error in the heat of Brexit? Oops, we were thinking it was supposed to be dealt with one way when there was going to be a no-deal Brexit. If there had been calmness within the civil service and whatever, we might have gone back and resolved. In other words, it's just a mistake, the presence of
Yes.
this exception. That must, I'm afraid, be one possibility. But the court doesn't need to accede to that, because actually we say there is another possibility. It is the one that has been adopted in all the other judgments. It is one which, in my submission, if correct, and I will explain why we say it is correct, also assists to answer my Lord Justice Arnold's broader question about the temporal issues. And it's important that I do answer it, because of course Lady Justice Falk raised the question, well, what are these provisions there for?
Right.
In a world in which that we appear to be saying they have no effect whatsoever. That I think is
These provisions, you mean specifically?
sorry, the brackets.
Well, not most of the stuff in the brackets is understandable. Certainly, the exclusion, if you allow me to use that word for a second, of 86(2) and 4 is perfectly understandable. It seems to me, because it requires you to give notification to an EU.
But I think I
office.
can do better than that, my lord.
Okay.
Let me pick you up exactly
I'll
on that
let you
point.
do it. I'll let you do it.
You have a problem in my submission where you have an explanation that explains some of them but not others.
Well, quite.
And my learned friend runs into that because he fully and fairly accepts that he can't really reconcile the presence of Article 91 in that list with the retention of reference to 91.3 later on.
Right.
Indeed, he's got a bigger problem than that, because we say, if you follow his logic through, by referencing Article 91, not only did they not want it to apply, they expressly wanted to disapply any equivalent common law provisions.
Rather than tantalise us with these points, let's look
My
at
lord,
it.
could I ask
See
you to
what you
take
are saying.
up the relevant provision, and I've gone to it in the judgment, which is in the core bundle at page 78.
Okay.
But of course, my lord will find it
No,
also in the
that's fine. That's why I looked at it first. Oh, did you say in the judgment?
Yes, sorry, I've just taken it from there. I'm afraid my
If you say page 98, that's the judgment. It doesn't go to page 98.
sorry, page 78 of
78.
the core bundle. I do apologise. 78.
Yep.
And it's paragraph 21 sub 4,
Yep.
where paragraph 9 is being set out, and the relevant paragraph is at 2. And Mr Justice Zacaroli has highlighted the key words. Let me say what we ask of you. That provision we submit, and the judge so held, is a positive statement of the continued application of certain provisions of the Community Design Regulation. The identification of those provisions, i.e. the ones that are positively being applied, is done by referencing them compendiously as those in Title 9, but excluding from that reference a small subset, in brackets, 86.2, 4, 5, and 91. So the express wording of the section is, we say, directed towards the positive continued application of the identified provisions. And that is something that is apparent from the shape of the wording itself. The provisions contained in or referred to in Title 9 of the Community Design Regulation shall continue to apply in the pending proceedings, except, insertion, small brackets, not these ones. So when my lord says they're excluded, they're not excluded from application, they're excluded from the reference, the identification that's being given in section 9.2 of those that are positively to apply. Now,
I see that as a matter of language,
yes, but as a matter of purpose, my
but
lord.
a matter of substance.
Yes.
Why you would, in most circumstances, think
Yes.
it came to the same thing.
Well, the reason why we say it was done is that, let me put it by reference to how Lady Justice Falk put it in the permission to appeal. She said the question of the purpose of the wording in section 9.2, accepting certain provisions, required explanation.
Yes.
But we say that's the wrong question. The 2020 regulations are anxious to expressly ensure the continued application of certain provisions. They are agnostic as to the status of those that are being accepted. Excuse me, accepted, not accepted. They don't care. That's not a subject for these regulations. It's the point we're making at paragraph 41 of our written
An
submissions.
odd thing for the draftsman to do, isn't it?
Well,
Say,
not-
I know I want all these ones to apply. Not sure about the others, so I'll just let them.
my lord's ahead of me. Because the reason why they're agnostic is that they know that these regulations are only coming as part of a whole suite of legislation, which includes the provisions of the Withdrawal Act and the consequences of the withdrawal agreement. They're content, the 2020 regulations are content to leave the relationship between the EU IPO and the UK court, whether sitting as a community design court, between the EU IPO and the UK court sitting as a community design court, or between the UK court sitting as a community design court and other community design courts, to be dealt with separately. In other words, the reason for the exceptions is not to take a positive step in relation to them, but to leave their status unaltered by the 2020 regulations itself.
2019 regulations.
Well, of course, by the time that they're made, they're in the form of the 2020 regulations.
Yes.
Now, of course, I don't mind that you reference the fact that they were there in the 2019.
They haven't come into force. It's not quite the same thing.
Sorry, you're quite right, my lord. The point I was about to make is that there's no difficulty with why they were kept between 2019 and 2020 on our explanation. Because, or that wording was kept, because it was always understood that those particular provisions would be left to be dealt with by the overall discussion with the relationship that was to be thereafter between the UK
Yes,
and
but
the
you're
EU.
not saying it's not important. Surely it is important to say they're in the 2019 regulations, because isn't this the structure of your argument? That at the time the 2019 regulations were made, nobody knew what would happen.
Yeah.
And it was important then to be agnostic about some things that you thought hadn't yet been agreed.
Yes.
Then come 2020,
Yep.
when there's no reason for agnosticism anymore because you know what has been agreed.
Yep.
But there's a perfectly legitimate inertia in saying, well, this is how we drafted it originally. We don't need to take these words out because they were intended to leave a door open for what happened in the eventual agreement, and that has happened. That's fine.
Absolutely. And we know what has happened. The withdrawal agreement has happened. It's happened in the terms of Article 67, with the result that, in fact, we know as a function of that route in all the provisions of that title apply. And that's exactly what you would expect to have occur, right? If your view is we're not quite sure where we're going to end up, and all these are doing is holding the ring in that sense, they're saying we don't need to positively apply them.
But what do these provisions, 86, 2, 4 and 5 and 91, have in common that they were to be treated differently?
That they were to be dealt with as a matter of agnosticism.
Yes.
I think the answer is that some of them are dealing with the relationship with the EU IPO, and others are dealing with the relationship between the UK sitting as a community trademark court and other community trademark courts. That's why they were considered to be the sort of thing that might be dealt with as a matter of a more general agreement on things going forward. But
Interface provisions.
interface provision. My lord puts it very well. I'm now doing to you, my lord, what I used to do to Lord Justice Arnold. Exactly. You put it much better than I could put it, and I agree with that. But the happy result of that, my lords, is that instead of being forced into a position of having to explain why these are exclusions, one understands that they are simply saying, look, we're not dealing with these particular provisions in the 2020 regulation. And then the problem falls entirely away in our submission. As I say, it's possible to conceive ultimately of a different withdrawal agreement that dealt with the relationship differently, in which case Article 67 might have looked different. My lords, this quite happily also brings me to ground 3. And we do submit, as you've already heard, that it's dependent on success on grounds 1 and 2. And so in addressing it to you, my lords, I'm addressing it on the premise that Article 86.5 is not a provision regarding jurisdiction, and that the construction of Section 9.2 is not, as I've submitted to you just now, simply of positively applying other provisions, but in accepting them, it's also seeking to disapply them, and indeed to go further, as my learned friend now seeks to argue, not only to disapply them, but to go further and disapply the common law provisions that are said to be equivalent. Now, if we pause here, we say that my learned friend's submission already runs into paradox, because what's said to justify the drafter's approach is a desire to remove not only the jurisdiction of EU law and replace it with UK law, but simultaneously to displace UK law. Now, the first point I was going to make was about Article 91, because my learned friend we submit has not followed the logic of his position through, because if that's what they were trying to do by this passage in brackets, they must be seeking to disapply all of the effects of Article 91 as well. Otherwise, we don't understand why some are in there and some aren't on his argument. In fact, it now seems from his oral submissions to you that he accepts there's a problem with Article 91. Once he accepts there's a problem with the presence of Article 91, then we don't understand how he thinks that there's cohesion to the rest of his argument as to what the drafter was trying to achieve by putting those articles into the brackets. We say it would be bizarre to try to disapply the equivalence effects of Article 91. My lords have looked at it. It's addressing the relationship between proceedings brought in more than one community design court. And in its final provision allows stays where a community design court is already seized the matter. But if there is a stay, to provide for provisional protective measures. Well, my lords, if my learned friend's argument is right, that also has to have been disapplied, including all of the powers that the court has under its inherent jurisdiction and under the Senior Courts Act. And we say that's a very surprising result when it's not even discussed or mentioned. A similar problem arises when one considers what has been positively said to apply, and that includes Article 88. They say, my learned friend says in his arguments, that the disapplication of national law is to be understood as, effectively as a question of inference, of implicit effect. But that doesn't account for the express terms. Section 9, introduced into the Designs Act, expressly applies the other provisions of Title 9, including those set out at Article 88. And as we've pointed out in our written submissions at paragraph 55, that article expressly states that national law is to address all matters not covered by the regulation. In other words, that national law would flow to fill any of the gaps, including by way of the usual provisions as to res judicata. So we say it's simply not sustainable on the express wording to suggest that this implicit or inferential consequence applies so as to make his ground 3 good. It certainly, we say, makes the absence of any discussion on this point, either in the legislation itself or in any explanatory material, deeply stark. My lords, just to go back on motive, because it arises in this context, we do say there's a further problem with my learned friend's argument, precisely because there is no discussion of this express exclusion of equivalent UK provisions. It means that my learned friend's motivation is speculative, motivation of the drafter. And my Lord Justice Underhill put it this way, it's a downhill point. Because they haven't talked about it, both sides can say, well, provided I'm right, the position must be consistent. We think actually the position is more difficult. Even if one assumes an intention to remove the EU provision at Article 86.5, it doesn't follow that one intends to remove the UK res judicata provisions, because those provisions are of different scope. Not only do they include cause of action estoppel and issue estoppel, but they also include Henderson and Henderson abuse scenarios. In other words, the drafter might have been thinking to himself, by removing Article 86.5 and returning the power to the UK, it's for the purpose of expanding the circumstances in which a block might occur. But more importantly, for my earlier submission, whatever the position will be a consequence of UK law. And if the UK law changed, for example, and I accept it's probably hard to believe that that might be the case, but if it was expressly under UK law, the position that res judicata was removed, then by treating 86.5 as agnostic under the 2022 regulations, you wouldn't thereby risk a clash. In other words, it supports what I say is to be understood as the agnostic argument for why those were accepted. It allows for the possibility of modifications to the English doctrines that would flow into the gap without the need to be concerned by the remaining constraint of an EU law provision. And that, we say, is in fact consistent with the content of the footnote in footnote 12 of my learned friend's skeleton. My lord, validity versus invalidity.
Just as a general point,
Yes, my lord.
considering that the purpose of a lot of this was to return powers to the courts in this country,
Yes.
It would be a funny thing if the consequence of all of this was actually that the court didn't have its ordinary daily powers to run its business.
My lord is absolutely right. And that indeed was the submission I opened with. It's a remarkable proposition that my learned friend comes before you to say that somehow, without it being expressly said, the purpose of this
Well,
section in
a
brackets is
submission through implication that's being made to us might float if that was the general direction of the wind, but it's not.
No, I'm in agreement. My lord, validity versus invalidity, I think I can deal with that briefly. We've addressed it in my written submissions, paragraphs 51 to 54. My lord asked a question of my learned friend, which foreshadowed the main argument here, which is that given that there's a default position of validity, the alleged imbalance between validity and invalidity in the legislation is neither here nor there. I don't think I need to say any more than is in my written submissions. That means, my lord, that I turn finally to the temporal issues that my Lord Justice Arnold raised. And this is obviously specifically directed towards the status of the counterclaim against the RCD. Oh, sorry, I say, my suspicions are about to be addressed to that particular aspect of the temporal issues.
It's relevant on both parts because we also have to consider the position with regard to the UK re-registered design, bearing in mind there's infringements alleged in January 2022, which on any view that's post-Brexit, and a counterclaim specifically against the UK RRD, as well as against the community registered design from which it derives.
Yes.
I don't know whether it's a useful intellectual exercise, but one could imagine that the allegations of post-Brexit infringement would not have been made by amendment to the existing proceedings, but by a fresh claim.
Well,
and the two no doubt be case managed in parallel, but it makes it a little bit more stark.
yes, I understood the implication of my lord's point about temporality was that the introduction of new claims for infringement would not be pending proceedings on that analysis. But our answer meets both. In other words, we say that the ultimate position I ask the court to find is that the consequence of all of this legislation is that for pending proceedings, they carry on in this bubble, even if new matters are introduced into those pending proceedings after IP completion day. And that is it's in that context I say that the contrary conclusion is not compelled.
It's one thing to introduce a new claim about what happened pre-Brexit. So take an analogy. Suppose you've got a contract claim about pre-Brexit events and you amend to plead a parallel cause of action in tort. But again, it's about what happened pre-Brexit. Now, I don't think one would have too much difficulty with the idea of that's all part of the pending proceedings. But this is different because it's not simply new legal arguments based on existing facts. This is facts which arose post-Brexit.
Yeah, I understand that, my lord. I understand the point that you're making. That's why I say I understood that the difficulty you're raising with me to address applies not just to a counterclaim for invalidity. It's not specific to that issue. It applies to anything post-IP completion. I fully accept that. And my answer to it is, as I say, that the way that the scheme of the legislation works is to treat pending proceedings as a special category, and they flow forward as if they were in a kind of unique bubble. And
What is the skin of the bubble? Is the skin of the bubble that procedurally it's all part of the same proceedings? Or might the bubble, if the subject matter were the same, but as a matter of tactical choice or the peculiarities of a particular procedural system, a closely related claim was brought in fresh proceedings? Do you follow me?
I do understand your point, my lord, and I'm reluctant to engage with it for this reason, because it might be that there are nuances that exist outside of the context that I'm dealing with today, where I don't need to tackle the full scope of the skin, because my submission on this particular occasion is that what we're dealing with is all concerned with the same right that was in issue at the outset, and that's part.
It's a new right. It's the UK right, which is the same design and it has the same substantive content, but it's a distinct right.
Indeed, and I think I have to accept, and my submission to you is that the way that the scheme works, pending proceedings were treated as a special creature, and that they operated by way of allowing those proceedings to continue under the.
But what's the logic of applying that regime to post-Brexit facts?
The answer is because, and it's most stark, I think, in the context of a counterclaim for invalidity. Otherwise, one would not have certainty as to what the position was between those parties. And my learned friend's example is a very good example of how it might result in injustice. Because you might, for example, have brought a claim for infringement of a design. The counterclaim for invalidity is only made after IP completion day. But in this scenario that I'm addressing you on, there's been no prior validity claim in the EU IPO. This is the first opportunity. My lord was right. Then there would be no opportunity for the defendant in that case to be able to rely on as a defence to the infringement claim of the RCD the fact that it said it was invalid.
I understand that point.
Yes.
But that's still referable to the events pre-Brexit, I don't see how, let's assume that's right.
Yes.
How does that justify applying the same regime to events which only occur post-Brexit?
Well, my lord, the first point to make is that we've slightly shifted the ground now, because the beginning was the concern about what had happened in this case.
Well, it
namely,
is.
the date of the
So
counterclaim.
there's two questions.
Yes.
And they don't necessarily fall the same way.
No.
The answers don't necessarily fall the same way. So question one is, what's the jurisdictional position with regard to infringement claims and validity counterclaims concerning what happened in the period to 2014 to 2018 pre-Brexit? And you and Mr Vinehour are ad-idem that the structure of the legislation, where there is a pending infringement claim as at IP completion day, permits a post-Brexit counterclaim on validity.
Yes.
But the point of that, as you were just articulating, is to provide a defence to the claim for infringement with regard to the pre-Brexit events. But even if we assume that that's correct, why does it follow that if there is then a claim for infringement by post-Brexit acts, that has to be treated in the same way?
Because the way that the withdrawal agreement has dealt with the question of avoiding arbitrary and uncertain results is to treat the UK court as continuing as a community design court, because it was first seized as such.
I'm sorry to interrupt, but let's take it in stages. If it was a fresh claim form, you couldn't run the argument, correct?
Yes, because it wouldn't be impending proceedings, correct?
Right. So it all comes down to the fact that you've been permitted to amend the particulars of claim within the existing proceedings.
Yes, to be clear, my lord, the amendment that was made was simply to identify the nature, the true name of the...
No, I'm sorry, that's not correct at all. The amendments bring in January 2022 acts. That's clearly the effect of it.
Sorry, my lord is quite right that they
Paragraph
reference...
90A. This is all new.
Yes, my lord, but it...
Core bundle tab 13, page 123.
Yes, my lord. Yes, my lord. But if you look...
Following the issue and service of the claim form. I mean, it couldn't be more explicit.
if my lord looks at paragraph 26 on page 126...
Sorry, I'm behind.
Sorry,
I hadn't necessarily follow up to that point. I think it is now.
It's the core bundle, my lord.
Yep.
Within the core bundle, it's behind tab 13. It may be that there isn't actually a great deal between myself and my Lord Justice Arnold, but just for the full picture, if one looks at paragraph 26, it was already the position, and you see that in the bit after the first new amendment. In addition to infringing the RCD, the aforesaid acts by the defendant in the United Kingdom will, to the extent that they continue or are threatened to continue after the withdrawal of the United Kingdom from the European Union, also infringe and it wasn't known then that it would be called the RRD, so it was referred to as the Comparable UK National Registered Design. So the point I'm trying to make is not that there wasn't a significant amendment, nor that the reference to the specifics of January 2022, which my Lord Justice Arnold referred to, and which is to be found at 19A back on page 123, wasn't introduced subsequently, but that it was already in contemplation.
You say you're just identifying a continuing infringement.
Threatened infringement, yes, my Lord. That is our position. I'm not sure that necessarily meets Lord Justice Arnold's concern, but what does, I hope, meet Lord Justice Arnold's concern is that what we say is the solution that has been provided to these sorts of problems, and in particular to the problem of the counterclaim for invalidity that I was touching upon as the touchstone for all this, is that they've said, well, look, for pending proceedings, just carry on as if nothing had changed. And to the extent you need powers to give effect to that, we'll give them to you in the regulations. That's what we say has happened.
But the logic of that appears to be, and I think I've written you down as accepting this, that if you had chosen to bring your claim for post-IP Day infringements in separate proceedings, as a matter of
Separate proceedings.
Sep-
Sorry, for the 2022 reference, yes.
yeah, exactly HP 2022 something or other.
Yes.
It would not fall within the it would not fall within the solution offered by Article 67 because it would not be pending proceedings.
Yes.
Pending proceedings can be given quite a wide definition, and you say were, so as to include subsequent counterclaims and so forth.
Sorry, so that you can answer it together, I'd just like to fit Article 67(1) of the withdrawal agreement into this. What's the relevance of pending proceedings and proceedings or actions that are related to such legal proceedings? Has that got anything to do with this,
Yeah,
or
well,
am I on a different pitch?
I don't know that you are on a different pitch, my lord. That is the question that was being addressed, I think, in Simone.
Yes,
Yeah.
exactly.
The trouble.
So why? I mean, you're surely right if you're conceding something. If it's the case that you're going to accept that, if you've decided just to start a new action, saying, you know, we sued you once, so now we're suing you again for you continuing the same things.
Yes, and A40, you're right. If, as might be the case, apparently it's not the case here, there was no real issue about the acts of infringement. The only question was validity.
So why would those not be related proceedings, or why might you not be able to argue that?
Well, no, my lord, I would be arguing it. I think where we've parted, or where I may have appeared to make a concession I didn't mean to, is that my assumption was that we were talking about a scenario in which there were no ongoing
Talking about what, sorry?
a scenario
Yeah.
in which there were no ongoing proceedings, and I've
Oh.
started afresh.
Oh, I see. No, no.
Because what I
You can't
can't
be related
understand
to
is
some-
why my
No,
lord
no, okay.
considers
So,
that my
but-
client would have a set of proceedings ongoing, but go, I tell you what, I'm not going to do anything. Even though it's the same design, I'm going to go over here and start. I just can't understand that.
We
So,
used to
Well,
have to do that.
Yes.
Because the old rule was you couldn't rely upon causes of action arising after the date of the writ.
yes.
And it took a series of decisions of this court to establish that at any rate post-CPR, we're not bound by that principle, and you are now allowed to do that which you have done, which is expressly to plead post-claim form acts as being infringements. So that's now permissible,
Yeah.
but under the RSC, if it was a writ, you couldn't do that.
Yes.
You had to issue a fresh writ and then consolidate.
I know, but my lord, I do moisturise, and so I look younger than I am. But even I only just saw the RSC.
Yeah, well,
my lord. So,
I'm
accept
giving us
that,
the opportunity for that joke, but it's really, it doesn't, even if it was done by mistake, one can imagine all sorts of contingent or procedural reasons why. Let's not bother about trying to amend. We'll have all the problems. Let's just start fresh proceedings. And that may be rather unusual circumstances in which you do it, but no one would doubt you could do it. And they would simply be, if not formally consolidated, they would be heard together. And the answer to all this, which my lord suggested to you, is that in fact 67 goes further than pending proceedings, but it also includes related proceedings, which, as he says, is the point in Seymour. And no doubt there are some limits, and there will be some fact-specific cases where you have to decide whether they're related or not. But that's your answer, isn't it? And am I missing something?
no, my lord. Save that a sense of caution on my part, because if my lords turn to the wording at 633 of the authorities bundle, to which I think my lord is referring, the chapeau, if I may put it that way, the body of paragraph 1, talks about, in respect of proceedings or actions that are related to such legal proceedings, pursuant to Articles
Yes, well,
29, 30.
I didn't know what those were, so
It's
that's
the,
why I'm
it's the lis alibi pendens provisions in Brussels 1.
right. So does that mean that this is not relevant? What does that mean?
The answer is, my lord, I don't know off the top of my head. And that's why I'm cautious about relying upon that in saying
Right. So
that's
you don't
where-
want to prove more than you need to.
that, I'm afraid I'm just being cautious, my lord.
So your case basically is all very interesting, but this was done in these proceedings from a purely technical case number point of view.
Indeed, my lord. Indeed.
And who knows what the position would have been if we had done another route, but we didn't.
Yes. And I want to go further, if I may, and just specifically address the counterclaim point, because even without relying upon the wording which my lord has pointed to, I think it's relevant to look at some of the wording in the section that has been
Yeah, because
introduced.
I'm still troubled as to how the counterclaim works. I mean, even if you're right,
Yes.
suppose this is related proceedings, but you know, how does this work? Because your proposition is we have a bubble of EU law which is continuing to apply. But then how does that work when you get to the counterclaim? Because it can't, because it's a UK right.
No, I'm only talking about the RCD, my lord. It's the
But
counterclaim
this is
against the RCD.
infringement of the UK design.
But now you've moved back to infringement, my lord. I thought we were talking about the counterclaim for invalidity of the RCD.
No,
But it's
but-
both. It's
yeah.
both.
I know it's both, my lord. I do
So
understand that.
how does
But
it? How,
I'm
but my question is,
specifically
how does
addressing
this
you.
work for the counterclaim with respect to the declaration of invalidity of the UK re-registered design?
So the answer there is that the judge has held that the comparable effect of Article 86.5 maps onto the RRD as a consequence of the provisions under Section 9. Lord Kitchen, in that final subparagraph that I referred to at 451, does not appear to follow along with that. That's why at the very opening when I said ultimately 451 is where I want to end up, and the judge ended up in consistent position with that, save in that one respect, it's because following Lord Kitchen, the counterclaim in respect of the RRD is not dealt with as a reference under community law, it is dealt with under the UK law. But that has always been our position and is reflected in the judgment in what's said in paragraph 70 and 71. So that's why I've been focusing on the RCD, my lord. And I hoped I had made it clear that my submissions were about the counterclaim to the RCD, because that's the context in which my lord was saying, well, how can you apply community law?
Well,
to
my
the
lord
RCD.
was saying the RRD as well.
Sure, my lord, but there are two answers to that. The first is you map it across as a consequence of the effect of treating the validity of the RRD the same as the RCD. But if you don't agree with that, and I've got to look at the wording, then we say, well, all right, in that case, it's just the UK's normal common law provisions against res judicata and so on and so forth. Sorry, not provisions against res judicata.
Yes.
You just bring us a matter of normal.
So, so when you say map across, we haven't focused on this. I must have read it when I read the. You're effectively saying what the judge said is that a finding that it was invalid because the substantive content of the RCD and the RRD are the same, or the substantive conditions of validity are the same. Once you have found the one, you found the other.
Yes.
Once you found the RCD is invalid on those grounds, you have necessarily found the RRD is as well.
Yes.
That's what you mean by map across?
That's exactly right, my lord. I think I've become unanchored from what would be a useful anchor, which is to look at the actual wording of the sections, because in trying to meet the questions, I'm very conscious I've got to leave my
No,
learned friend enough time.
you will leave time for reply. We're nearly there, but
Indeed. I mean, the oddity perhaps of all of this is that from my client's perspective, it's not ultimately going to make a great deal of difference. I think what my Lord Justice Arnold is saying is that we've missed another ground on which we might have said that they aren't in a position to bring a counterclaim in respect of the RCD.
Not necessarily.
No, not necessarily. But,
also we just want to get the law right
but indeed,
for the future. But
indeed.
the other handful of cases that are possibly coming.
So, well, we understand we're it, my lord.
Are you?
So-
Yes. Well, it doesn't wholly
I may be
surprise
wrong
me,
about
but there might be others which we don't know about.
Yeah. So the relevant paragraphs in the judgment are those at 70 and 71. On page 89 and 90 of the core book. And if you look at the first sentence of paragraph 71, I understand from the way the judge has phrased it there that he must be understanding his primary position to be that Article 86.5 has application to the re-registers.
Yes, because that's what he understood both parties to be saying.
Precisely. Or, yes, or that it should go the same way.
Yeah.
But he says, well, if I'm wrong about that, then it doesn't matter because they're caught by res judicata anyway. It helps, my lord, to understand how he was led to that position, because it may be that in the light of what my Lord Justice Arnold has raised, we created a confusion that didn't need to be created. But if my lord takes up the supplementary bundle, and turns within it to tab 5, the arguments that we were putting forward were summarised first at paragraph 15, and my lords will see that effectively what's being said there is that 86.5 is applying to both the RCD and the RRD, but at sub D. So, sorry, where are we? Sorry, we're at paragraph 15, it's page 57 of the... But if we're wrong about that, then it's okay because we're covered by the common law. But if you turn over, my lord, at paragraph 17, we give an alternative analysis and it's the one I think that is consistent with what's being discussed today, in particular at 17C. In respect to the RRD, the domestic legislation applies, the EU design regulation does not apply, but still court. We then go on to add that that would be consistent with the effect of Article 67, although probably that's not relevant. But that, because as it were, those two horses were both being run, that may be why in the judgment it's come out in the way that it has. What I need to do before I sit down, my lord, is just try to put the detail to what I had foreshadowed I was going to try to do, at least in respect of the counterclaim for invalidity of the RCD that was brought after the IP completion date. And the first proposition I wanted to make was that section 9.4 itself did not compel the conclusion.
This is paragraph 9.4 of the Schedule 1.
Thank you. Yes, that's absolutely right, my lord. And again, I've just been taking it from where it's set out in the judgment.
Yeah.
And that is to be found at page 78. And it is the point that we made in our openings, in our skeleton at first instance. The identification is of pending proceedings, but the definition of pending proceedings is given up at the top. And it has as its test that an existing registered community design is the subject to proceedings which are pending.
Yeah.
That's all that's required.
Yeah. So no particular kind of issue or...
And no reference to the timing of any counterclaim.
No.
Otherwise, no challenge, as we say, could be made back to a claim for infringement. And indeed, as my lords pointed out this morning, it's not the purpose of 9.4 to have the effect of preventing subsequent counterclaims. It's about the ruling on an RRD resulting in something equivalent to whatever's happened to the RCD. And although it's infelicitously, or I should say not clearly worded, we say that that is what the judge must have been relying upon in his understanding that whatever was sauce for the goose was sauce for the gander. In other words, if Article 86.5 still had the effect on the RCD, then 9.4 is trying to say the same consequence will flow for the RRD. And the reason I say that in particular is that it says in 4, where the pending proceedings involve a counterclaim for a declaration of invalidity in relation to an existing registered community design, so the trigger is by reference to the RCD, the community design court may declare the registration of the RRD, which derives from the existing registered design, to be invalid. It must follow that if 86.5 bars the RCD from being considered, there's no jurisdiction to do, a dangerous word to use, no power to deal with the RRD. That's, as we understand it, how the judge came to the conclusion that he came to. Namely, you're supposed to treat the two the same. And of course, we say that's consistent with the purpose. And it's why it moves from talking about the trigger being an RCD as an issue to the consequence being one for the RRD. And that's why I think probably I should have taken you directly to the wording, because we do then say, when you look at Article 67, and indeed we say also at the paragraph 7A of the 2018 Withdrawal Act that was introduced by the 2020 Withdrawal Act, that says you're supposed to treat the UK as effectively a member state, where the provisions of Article 67 have said that will be the case. What you are achieving is this objective of having the UK court in pending proceedings only just carry on as if it was a community design court, and where there might have been a gap in the power of the UK court as a community design court to deal with the RRD, they've covered it off by reference to either 9.3, 9.4, or indeed later 9A. That's the scheme that they've dealt with it under. That's why we submit that effectively Article 86.5 does impact on the RRD, as the judge found. But if we're wrong about that, my learned friends can't still caught, because all it means is that you just get caught by the common law provisions. And we do say that when you look at Lord Reed's judgment, for example, at paragraph 498 on page 252, that's consistent with our understanding, because he only talks there about where the proceedings are pending. He doesn't talk about it in terms of being limited to those that were initiated or had a claim beforehand. And we do say that Simone is supportive of that conclusion, precisely because it talks, particularly in what it says at 71, where it quotes from the notice to the stakeholders, in terms of the aim being to ensure that there's no disruption by allowing you effectively to crack on as if nothing had changed, but only for pending proceedings. And so that, my lord, is why, at least in relation to the counterclaim for the RCD, we say it's not an issue that it was brought after IP completion day. Now that doesn't directly address my lord's question about infringements that occur after IP completion day, but we say that once the scheme has said, okay, the community design court, the UK court still functions as a community design court in order to avoid problems with invalidity claims, counterclaims of this kind, then it's just there as a community design court, and it just cracks on in those pending proceedings as if it was a community design court, with all of the powers that have been expressly included in Title IX, which includes jurisdiction over infringements, and which includes the application of community trademark law, and which includes the powers that are set out therein. In other words, it comes as a package, and that's how they've dealt with pending proceedings. And it makes complete sense, because you know where you are. Everybody knows where they are. If it's pending proceedings, it's the old law until such time as they come to a conclusion. And it's clearly supposed to be a final conclusion, because expressly appeal courts are said to be covered by that provision as well.
Is that it?
It is from me, my lord, unless my lord's had any questions.
No, thank you very much. Respondent.
My lord, four short points in reply.
Yeah.
First, in relation to the term regarding jurisdiction, the makers of the withdrawal agreement have made a decision to apply some but not all of the design regulation. Doesn't say they just have to carry on entirely with no changes at all. What they have to keep are, as a derogation from the fact that the UK is now no longer a member state, they have to keep the provisions regarding jurisdiction. And the distinction that we say this court should draw, contrary to Milan and Friend's submissions, is that the court, the UK court here, is given, or the Community Design Court, is given jurisdiction to consider counterclaims. And then there are rules about who can bring them, when they can be brought, what can be in them. And we say that's the line. It's not about, it was suggested that if the test is the rules about which court can do something, then Article 86.5 fell on the wrong side of it. No, it doesn't, because Article 86, we already know that the English court has the Community Design Court has the power to hear infringement claims and any counterclaims that are available under the law. And that's the jurisdictional bit. And Article 86.5 tells you something about when the parties, and it's expressly in its language directed to what the parties can do, can bring a counterclaim. So that's what I'm...
Mr Brown's submissions was that a useful synonym for jurisdiction in this context was competence. What would you say to that?
I mean, if I was translating it into French, that's what I'd go for. I'm not sure I can discern any particular difference in the shades of meaning between jurisdiction. I don't know if that is the word that's used in the French text. I'm not sure I can add anything intelligent to that. I'm sorry, my lord. But I mean, if one was applying that term, it would be the same. It's still a rule that is directed to what the parties can do, not what the powers, not the competence of the court.
If one views it in terms of competence, Article 86.5 tells you that the UK court is not competent to deal with it.
Well, it tells you that there is a particular... It's not that, with respect, it's not that there is a claim out there somewhere that somebody can deal with, and it's not the UK court. It's that this particular species of claim simply cannot be brought. And we say that's substantive. It doesn't go to the competence of the court. It goes to the substantive rules about what claims can and can't be brought. So that's my first point. My second point is about the agnosticism construction. And we say that that is fine in circumstances where the national court is trying to shoehorn national legislation into what it has found to be its withdrawal agreement obligations. And that's, no doubt you can resort to that kind of mar-leasing exercise in that situation. But as a conventional exercise in construction about what, in purely UK terms, this UK regulation was trying to do, it is with respect hopeless. And the reason why my learned friend sought to, quote, avoid being forced into a position of needing to explain why these are exclusions is because he can't. Because the only explanation in my submission is that the legislator was trying to keep in force the whole of Title 10, except the ones which are excluded. And that must mean that the legislator was making a choice that counterclaims of the type that my client has pleaded should be permitted where otherwise they would not be.
Mr. Brandreth at least hinted that of course it would all just be a mistake, and that if it was just a mistake, the requirements of the primary legislation must trump an inconsistent provision of the secondary legislation.
And by the primary legislation, your lordship
Withdrawal
means-
Act.
Oh, the Withdrawal Act.
Well, the
Look-
Withdrawal Act, because that gives effect to the withdrawal agreement.
No, look, I make no bones about this. If my learned friend is right, that this is, and the judge was right, that this was a provision regarding jurisdiction,
Yes.
then I fully accept that 7A of the Withdrawal Agreement Act trumps everything,
Yeah.
just as happened in
Well, that's
Sky.
why I put it to Mr. Brandreth that really, when push comes to shove, ground one is determinative to if it goes that way.
Yeah, and the reason why I've put it in the way that I have is that because the judge seemed to be saying that this agnosticism construction was a sensible construction of this legislation anyway. So I've got to knock that down as
Yes,
well.
no, I see that. I'm just trying to get in my head what the...
Yeah, no, this is withdrawal agreement is where it's
Yeah,
at.
okay, thank you.
Third point, res judicata. That was not conceded. Your lordships were shown paragraph 11 of my client's skeleton below, which is in the supplemental bundle, tab 6, page 94. It's right at the bottom of page 94. And it's a rather long and convoluted sentence. But the important word is in the second line. Defendant is consent to accept that if it is wrong on the above and the doctrines of res judicata and or Henderson apply as between the EU IPA decision on validity, ARCD and the counterclaim in the UK proceedings, and this is another important bit, in respect of both the RCD and the re-registered UK design, and they've not been statutorily supplied, then it accepts it is stopped. So what we're not doing is accepting that we're stopped even if res judicata doesn't apply to the RRD. So, and in terms of the judge's reasoning on this, your lordships were shown a minute
The
ago.
basis for that is the first point that's identified in paragraph 10, namely, doesn't exist as between EU PI and national courts, because the proposition being advanced was it wasn't a court of competent jurisdiction. And that's the point that was decided adversely to your clients by the judge, and that's not been challenged.
I accept that, but what I don't say is that it's not open to me now to make the submissions that I am making. They're clearly set out in my skeleton, in my submission, and your lordship should deal with them on their merits. So far as the judges,
Still on point 3, Reg.
yes, your lordship, going back to the core bundle, tab 9. Your lordship has just been shown this on page 89 to 90, where the judge says at paragraph 70 that the re-registered design, quote, follows the fortunes of the RCD. Refers to the express UK legislative provision that a declaration of invalidity kills the clone. And then he says, to avoid an absurdity, counterclaim for declaration of invalidity must be regarded, to use the language of 86.5, as a claim relating to the same subject matter and cause of action as the RCD. And then he says, even if 86 doesn't apply, it's res judicata. Now, as we've indicated, there is a distinction both in the withdrawal agreement itself and in the UK implementing legislation, between declarations of invalidity, which have to destroy the claim as well, and findings of validity. So the judge is wrong to conflate them. And my learned friend very fairly sought to explain and defend the judge's reasoning based on Article 86(5), but the correct position in my submission, which is, as my learned friend very fairly indicated, supported to some extent by what Lord Kitchen said, is that whether the claim in respect of the UK re-registered design is precluded is a matter of UK law, of English law, and Article 86(5) has nothing to do with it. There was a lot of discussion about the expressions we use, disapplication of national law or exclusion of equivalent UK provisions. And in my respectful submission, that's not quite how we put it. The way that the common law works, and has always worked, is that it molds itself around whatever is on the statute book. So it's not that we are saying that there needs to be an express exclusion of a particular common law doctrine. It's simply that if the legislator has implicitly expressed the view that a particular kind of claim should be permitted, then the common law will accommodate that.
Yeah.
And it's certainly not, with respect to my Lord Justice Peter Jackson, about depriving the court of its powers of management. It's simply saying that it's giving the court the power to entertain a case that we wouldn't otherwise be able to entertain. So it's not about restricting the power of the UK court. What it's really doing is it's kind of downgrading the UK IPO and downgrading the force of that decision by statute. That's how we would characterise it.
I understood the effect of your submission is that the UK court has got no, whether it likes it or not, has just got to hear the claim. And in these specific circumstances, lacks the ability simply to say, no, this is repeating exactly the same exercise as before. So I'm struggling to see how it's permissive. It's plainly restrictive.
Well, to this extent, it prevents the English court from saying, purely because there is a decision of the UK IPO on these issues between these parties, without more, that makes this abusive. Yes, it does restrict the English court to that extent. If there are additional facts, or its other case management powers are and discretions to manage its proceedings are entirely unaffected. But yeah, I accept that to that limited extent. The other point that should be noted, especially in relation to the
We're still under the heading res judicata.
UK, yeah, this is the last sub point under that. Is I should record, as set out in our skeleton below, supplemental bundle tab 6, page 95. Paragraphs 15 to 16. There are some differences in the way that the case is put now in the defence and counterclaim versus how the case was put in the EU IPA. Fourth and last point. The point, Lord,
Yes, my point is made very fairly in paragraph 12. The slightly different arguments are not relied upon as being sufficient on their own to justify disapplication of the doctrines if they would otherwise apply.
Well, I think all we would say is that when one is looking at the RRD in specifically, this is a right which has never been litigated anywhere, and it's a right where my client has pleaded particular arguments which have not been advanced anywhere, and that is relevant to the way that your lordship should look at it. That's as far as I can take it, I think. And then very briefly, in relation to the timing, I'll just set out where I understand that we've got to. There is and this very much follows the pattern of my lord's email last night, we've got a claim against us for infringement of the community right pre-Brexit. And for all of the reasons that my learned friend has advanced and that one sees in Skykick by analogy, and in the arguments that your lordship's heard today from both sides, this court retains the power to sit as a community design court and deal with the counterclaim that infringement claim is founded on an invalid right, subject to Article 86.5 if it applies, and subject to res judicata if it applies. So far as since that's in, and since the court's got the power to determine that, it doesn't even matter, because I mean, I'm not entirely sure whether the pleaded claim in respect of 2022 is meant to extend to the community right as well. But even if it does, it doesn't matter, because we've already got
ceased to exist in this jurisdiction.
It has. But in any event, even if that wasn't a problem, we've already got the counterclaim in, and it's either invalid or it's not, so it doesn't matter. So far as the RRD is concerned, the position that we're in is the same as we would be in completely separate fresh proceedings, which is that subject to the common law doctrine of res judicata, they're entitled to sue us and we're entitled to counterclaim for invalidity of the UK right. And it's as simple as that. My lord, those are the submissions that I was proposing to make in reply.
Yes, my lord, I know has a query.
I just wanted to say that your supposition about the French in Article 67 was indeed correct.
Right.
That that it appears 5 times in the first paragraph of section 67, and the jurisdiction is translated as competence.
Well, my lord, I'm very grateful for, in the absence of a junior, I'm glad I've got somebody to do my research for me. But in that case, I definitely submit.
I'm just carrying off here. I would guess it's competence in German as well.
I wouldn't presume to talk about German. I saw the other side had a submission about the German, which I've carefully ignored.
Yeah.
But so I definitely submit in that case that it means the same as jurisdiction.
Thank you both and your teams. Well, you both have them for those very helpful submissions, which really went to the heart of the matter in a very effective way. We will, of course, be reserving our decision. You will get draft judgments circulated in due course for the limited purposes identified in the Counsel General for Wales case. And although, of course, the clients can see the drafts, they see them only on the same confidential basis, and they should only be circulated so far as necessary for the particular purposes identified in the Counsel General for Wales case. And if there's any breach of that, people responsible may find themselves in contempt of court. Thank you both very much.
Thank you, my lords.
All right,